venue. It is extremely disconcerting that we know that there is somebody in the court system who is broadcasting minute entries day in advance of them being available to the general public and making comments, derogatory comments regarding my client in those comments that they post on Facebook. And the fact that we're putting this off seems to imply that the court isn't concerned about, and I don't believe this for a second, but it implies the court is not concerned about this extremely serious breach of protocol, which indicates from all appearances that the court in Maricopa County in general is prejudiced against my client, and that we need to at least continue this trial until such time as that clerk has been found out. And I think that Mr. Jeans needs to be called over here to explain what internal investigation is going to be done to find out who this offending court clerk is and remove that person and make sure that person has no further access to court records prior to the commencement of this trial. The appearance of impropriety is overwhelming. It appears that the entire court system here is prejudiced against my client, and that appearance can't be overcome simply by saying, we're going to go ahead and start.
There are two separate issues. What you've raised in your motion raises an issue that I think needs to be addressed. If there's a court employee that is engaging in improper behavior as it relates to this case or any other case, we want to know about it and we want to address it, and we will. The question is whether the behavior as noted in your motion, if true and if it was from a superior court clerk or otherwise an employee of the court, whether that's going to affect us here in terms of a fair trial. If the jurors don't see it, then it doesn't have that effect. I agree with you that this case, as much as any others, we need to address with the jurors proactively the fact that they cannot be letting themselves be exposed to any of this information. If any of them have seen it, then we need to have a discussion about that, and we will, and I'll be asking them. But that doesn't mean that if they haven't seen it, that we need a continuance. We'll address any issues relating to an employee, but my concern here in this courtroom today and going forward is there anything happening affecting Mr. Hulsey's right to a fair trial? You may believe that what you've put in your motion reflects that we can view the court as potentially having a bias against Mr. Hulsey. That's not the case. If there's an employee that's acting inappropriately, it will be addressed, and I will address this likely this afternoon with you. But from my perspective, it doesn't mean that we either need a continuance or a change of venue. Those things are not the result of the actions you described, even if true, if none of the jurors have been exposed to the information that you put in your motion.
Well, the problem is, Your Honor, that the standard is higher. The standard is that if there is the appearance of impropriety, then the court has to take action. And well, the appearance of impropriety...
Sorry to interrupt you. The appearance of impropriety relates to the trial judge, and your analysis of an appearance is not... I don't agree with you. I don't think that's the analysis for the behavior of a clerk. That's got nothing to do with this case other than the fact that he or she works in Maricopa County Superior Court. If what you've told me is true, again, I don't know that, but in terms of the courtroom, whether it's me, my staff, or those that are going to be involved with the case, your motion doesn't apply to that, and that's what I'm focused on.
Well, Your Honor, it does apply to that because, A, we don't know who the offending clerk is. That person is a self-described felony minute entry clerk who has access to court records and is not only accessing those court records, but is posting those court records a day before they are even available to anyone else. So we don't know who that offending person is. And further, it is a court employee. Now, whether it is your particular staff, Your Honor, and I have no reason to believe it is, and I'll state that on the record right now, but that doesn't relieve this court of the obligation, and it certainly doesn't take the stain away. And it's not just a situation where it's limited to jurors, Your Honor. We have the media broadcasting this matter. We have this going out on Facebook to the general public, where they're going to come back and talk to the jurors. It is more pervasive than simply saying, have these jurors heard this information or read this information? And then if I can move on to the next part.
Not yet. Not yet. Let me address what you said, and then we'll move on to the next part. First of all, we don't know for a fact that this person is a Maricopa County Superior Court employee. They've described themselves as a file clerk. There's a lot of people on the internet who describe themselves as things, and they're not those things. I understand your motion argues that they have access to minute entries. I'm not sure that that's the case because I haven't looked at it, and there is some question about when things are available on the various court systems and when they're not, and sometimes it's not clear. So I'm not convinced yet that there's somebody that's got access here, or simply somebody that's accessing public information and saying they are a clerk. I will note that you can at least draw a suggestion that they're saying they're a former clerk with some of the language that you cited. So I don't accept as fact yet that we've even got a Superior Court employee involved. And second, again, I disagree with you because I know what the integrity of this courtroom is, and that's first and foremost, and with these jurors, and I'll protect that. But it doesn't create a situation based on what's in your motion where either a continuance or a venue change is appropriate from my perspective. What else did you want to say? And let's move it along because we got to bring the jury in.
We have absolutely shown the court that it is a court employee because that court employee posted this document on the Juan Martinez support page a day before it was available, and you can tell that by looking at the date stamp on the minute entry and looking at the date stamp on the Facebook entry. We know it has to be a court employee because of the dates of those entries.
We'll address this issue, but I will tell you it's not that easy. We will address the issue, and I'll let you be heard on it because I, too, want to determine if there is court staff that is doing the types of things you said. It needs to be addressed. But we will address that, but not right now.
Second, Your Honor, then, we have to have rulings in advance of openings on the motion to dismiss the F10 and the F2 aggravated.
Thank you for bringing that up. You have a minute entry coming out. It'll be out either today or tomorrow, denying the motion on F2 and F10, and you will see that. But those motions have been denied.
I appreciate that right now, but the court is telling me that now I've got to adjust whatever I was going to say to meet that ruling. Next, though, Your Honor, is the fact
let me address that. I don't think you're surprised that I'm denying the F2 and F10, and if you are, you're not following what the Supreme Court said and every other judge in Maricopa County has said regarding the F2, F10 argument that you've made. That was not a close call from my perspective on the F2 and the F10.
The point is, Your Honor, one motion was pending since March of 2011 and the other was pending since September of 2012. But I'll move on, Your Honor. I understand what you're saying.
Hold on for a second. Don't make a suggestion that I haven't been addressing the issues in this court. We've had our challenges with respect to the issues. That motion is a motion that's been raised in many cases that was pending in front of a previous judge that just got caught up. I told you I was going to rule on it, but I had to adjust to many other motions that both sides filed in this case. So I don't appreciate the suggestion that it's just been languishing without it being properly addressed. I understand that you wanted to receive the ruling, and I get that, but the ruling's not a surprise, and it will be out in a minute entry likely today, no later than tomorrow, because I ruled on it last week.
And you ruled on the 404B motion this morning, but we still have three other motions that, that are outstanding now. Further, Your Honor, the circumstances of what happened last week in our discovering the clerk's posting of the minute entries before they're available to the public, the change of the order of witnesses by Mr. Martinez has completely interrupted our trial preparation for today. And at the very least, our opening should be at least put off for a day or two so that we can have the opportunity to finish our trial preparations. We had to switch gears last week. We had our work planned out. We worked on the preparation of the cross-examination of the officer based upon Mr. Martinez's representation of who he was going to call. We then planned on spending Friday, Saturday, and Sunday preparing for the opening, but because of the change of tactics, we suddenly had to change who we were going to prepare for. And to say that we have been ready for witnesses is different than saying we're ready for the cross-examination of the witness, and that cross-examination preparation obviously goes on as the matters go forward. Otherwise, there'd be no need to advise us in advance of who's going to be called as a witness.
There's an argument to be made that has been made in other cases that once somebody's on a witness list, everybody needs to be ready all the time. There are some judges that don't even have a requirement of notifying the other, one side notifying the other regarding witnesses. I'm not one of those judges. In my view, I don't like anybody playing games, and I want people to try the case straight up with notice to the other side. And that's why we're going to have the 24-hour rule. That's also why we're not going to start with Patsy Jones today, because I'm going to give you until tomorrow to prepare for her. But we are not continuing opening statements. We've known this is coming for weeks, and we're going to have opening statements today.
Your Honor, regarding Patsy Jones, it shouldn't just be continued until tomorrow, because we're going to be arguing these other motions this afternoon. It should be continued till Wednesday, so that we have a day to prepare for Patsy Jones, not say that we can prepare for Patsy Jones from 6 p.m. till midnight tonight.
I understand your position. We'll start with her tomorrow, not Wednesday. What else from the defense perspective?
That's all, Your Honor. Okay,
let's talk about jury instructions. Make sure that no one has any changes. Note that the defense sent over, I think, 2 requested changes last week. I've adopted those changes to the jury instructions. State have any issues with what's in the jury instructions?
No.
Defense have any issues with what's in the jury instructions?
Other than what's been noted, Your Honor.
Well, I made those changes you suggested.
Right. That's all we have.
Okay. All right. Let's talk about what we're going to do. We're about to bring the jury in. We're going to read the indictment first. They've already been sworn in. Second, I'm going to read the jury instructions, and then we'll start with the state's opening statement. I'm going to tell the jury we may go beyond noon, I just don't know, and they need to be prepared for that. Even if we end before noon, I can't see a way I would turn to the defense and say, go ahead with your opening statement. So my intent would be after lunch.
And just let me just make a record, Your Honor. We would move for a continuance of the trial so that we could file a special action. And if the court's going to deny it, which I anticipate, I'd ask the court issue a minute entry immediately so that we can have access to that.
Okay, and so the record's clear. I'm denying it, but let's make sure we know what issue you're referencing in the motion to continue based on
our motion for a continuance and our motion for a mistrial and change of venue.
All right. So it's clear. I am essentially granting in part the motion to continue because we're not going to start with Patsy Jones until tomorrow. The motion to continue, that's part of the motion for change of venue, I have not ruled on yet. I'm not ruling on it now. I'm not granting it. I'm not continuing the trial now. If you want to special action that, I'm denying any motion to continue based on your desire to special action, so that's clear, and we'll see if we can get a minute entry out. Probably, it won't be right away. It'll probably be, we're lucky at the end of the day because we're all busy doing something else in here today. Okay, are we ready to go?
Yes, sir.
All right. So Kim's going to go ahead and bring the jury in. It may take a couple minutes to get them ready.